Good day, Crime Talk aficionados. It's December 18th, a Saturday. What does that mean? All the top stories recapped right here for you in one convenient location. Thanks for watching Crime Talk. We'll see you next time. First, if you haven't done so, though, please hit that subscribe button, hit that little bell so you receive notifications of when we go live or put up new content. All right, first on the docket, what was the key factor for Jussie Smollett's conviction? Let's talk about what a juror had to say regarding the trial. So a female juror in the Jussie Smollett trial has come forward and explained the reasons why the jury felt there was no way they could acquit Mr. Smallett in his trial for staging the fake hate crime attack. Now, the juror said that the jury did not have any major disagreements when deliberations began, but they did take up to 9 hours to deliberate properly and consider all of the evidence presented. Now, this juror said that some of the jurors doubted that the prosecutors had proven their case beyond a reasonable doubt when the deliberations began, but those people really just wanted more time to look over the evidence. So Mr. Smallett, who is an openly gay black actor, for nearly 3 years denied accusations that he hired two brothers as assailants in this alleged attack. He testified in his own defense during this one-week trial, and the jurors said that they felt Smollett's answers didn't have credible reasoning, especially when there was zero evidence to back up his story. Now, the jurors said that the jury was eager to hear from Frank Gaston, Mr. Smollett's creative director, who initially called police in 2019. Now, Gaston was on the list of witnesses to testify, but was never called. Ultimately, the jury said the jury found testimony from the Osundario brothers hired to attack Mr. Smallett to be more convincing. The brothers gave very damning testimony that Mr. Smallett had paid them to carry out the task of roughing him up and slipping a noose around his neck after dousing him in bleach. The jurors also believed that Mr. Smallett had walked the brothers through a dry run the day before. The jurors stated that Mr. Smollett's defense attorney seemed to be just shooting from the hip with her approach to the trial. She threw out unsubstantiated claims that didn't sit well with the jurors. There was the claim that, for example, the brothers wanted a $2 million payout from Mr. Smallett to change their story. She said that, in contrast, the prosecutor, Dan Webb, had a methodical plotting style that made his argument seem watertight to the jurors. The jurors said that we were told it was an aggravated battery because Smallett said they were wearing a mask. This is according to the juror. But in all Smollett's accounts of what happened, he mentioned a mask. She added, "I just hope that Mr. Smallett and his attorneys know we went in there with an open mind. We listened to both sides. We wanted to make sure that those who had doubts didn't feel pressured." So let's talk about this. This is what I've said about doing trials for the last 26 years. First, you have to have a credible defense, okay? Jurors take their jobs very seriously. They do go into it with a very open mind, assuming that everybody has been honest in the jury selection process. And what was the key thing here? Mr. Smallett, according to the juror, didn't have anything to corroborate what he was saying. And if you look at any good case that's put together, the prosecution puts up a witness, and then they try to corroborate what that witness said, usually with some sort of documents or through other witnesses. So it's not just hanging your hat on what one person says. That's what jurors look for. They want to be certain that they're getting it right. Now, if it's just two people in a room and it's he said, she said, they'll make that decision. But what did this ultimately come down to? The juror said the Osundario brothers were more credible than Mr. Smallett in his version of the events. Now, the juror didn't say that Mr. Smallett lied, but let's face it, there was a pretty huge disparity between the two versions. So this wasn't just, oh, I perceived something differently in a crowded room. This was two distinct versions of events that either took place or didn't. The jury ultimately believed that the prosecution's case was proven beyond a reasonable doubt to 5 of the 6 counts. But it just shows you what I have said all along. Jurors take their jobs very, very seriously. They want to do a good job. They want to get it right. And whatever decision the jury makes, you usually have to respect it because that is the decision that they made based upon the evidence and the law that was presented to them. If there were legal errors, that's for a higher court to determine, but the reality of it is they always take their jobs very seriously. I've never seen a situation where jurors were dismissive of the facts or the law. This is the most important thing that most people will do in their life is jury service, and they want to get it right. And next on the docket, Alex Murdoch gets the bond. That's right. Disgraced ex-attorney Alex Murdoch spoke publicly for the first time in months on Monday in front of a judge. Now, Mr. Murdoch blamed some of his problems on his 20-year-long opioid addiction. Now, shortly after, the judge set his bond at $7 million. That's right. Now, the bond hearing centered on the charges handed down by a grand jury totaling 48 counts of breach of trust and fraudulent intent, computer crimes, money laundering, and forgery. The entire $7 million bond must be posted for Alex Murdoch to go on house arrest with electronic monitoring. He would have to get counseling and be randomly drug tested. Now, this all came down from Circuit Judge Allison Renee Lee in a virtual hearing. Now, Mr. Murdoch described to the court his frame of mind leading up to the events of that alleged day. He said that he had met with his brother and another law firm partner to confess a 20-year-long hidden addiction and to discuss my actions in the 24 hours before the attempted killing. He also said he was going through opioid withdrawal at the time. Now, Mr. Murdoch said he knew he had tarnished the family's legacy, but that he had improved since September and has not used any opioids in more than 3 months. Mr. Murdoch stated in court that his head is on straighter. He's thinking clearer than he has in a long, long time. He also wanted to deal with the charges appropriately and head on. He wants to repair as much of the damage that he has done, and he wants to repair many of the relationships, as many as he can. Now, on Monday, the attorneys for both Murdoch and the deceased housekeeper Gloria Satterfield's son announced during the bond hearing that some victims were nearing resolution with Mr. Murdoch, who is also accused of stealing insurance money meant for the Satterfield sons. The lawyers for both Murdoch and the Satterfield family said Murdoch had agreed to a $4.3 million judgment in this case, which is obviously subject to the approval of the court-appointed receivers who now control all of his assets. Now, Judge Lee's bond order surpassed amounts recommended by both prosecutors, who had recommended that the judge set the bond at only $6.2 million, which he's only accused of stealing 4.7, according to them. That's about $100,000 for each count. Now, Mr. Murdoch's defense attorney had asked that the judge set the bond at a maximum of $200,000. As indicated, they would ask the judge to reconsider her decision. His attorney stated that he can't post $7 million. He can't post $700,000. According to his defense attorneys, he has no money. Now, the judge probably did the right thing by setting a bond. Most people are entitled to a bond unless it is a capital offense. Mr. Murdoch has not been charged with a capital offense. And the judge made a statement before setting the bond at $7 million. She stated that about media reports questioning why she and not the judge who had been assigned to all of Mr. Murdoch's criminal cases would be here today. She said in an act of good faith by the Supreme Court that she was now presiding over the matters. She said, quote, "The reason I'm presiding and not Judge Clinton Newman is because I'm the presiding judge of the state grand jury." To summarize, what the judge said was a judge was put in place to build trust with a wary public. The judge made a decision that wasn't favorable to Mr. Murdoch. In a bold and very drastic move, Murdoch's attorney seems to have tattled on the judge and tried to go around his decision. If that doesn't work, so then the public is told there's a new judge for bond decisions. At the time of the hearing, Mr. Murdoch faced 3 charges related to the Labor Day shooting incident, 2 charges from the Satterfield case, and 48 charges from 12 indictments handed down by the grand jury in November and this December. So that would add up to 53 charges. Well, in this case, using Mr. Murdoch's math, the charges add up to 51. This is because 2 of the Satterfield charges were apparently converted to direct indictments and presented to the grand jury that way. What does this mean? It means the charges that fell under Newman's jurisdiction were now suddenly under Lee's jurisdiction. Not once was this mentioned to the public during the hearing on Monday. It's very unlikely that Mr. Murdoch is going to post that bond, and if he had an extra $7 million, well, he'd probably want to use it to pay restitution. Certainly would help, but he still more than likely needs to go to prison. Next on the docket, the parents of the accused Michigan high school shooter, Ethan Crumley, who's 15, appeared in court for a probable cause determination. Now, attorneys for the parents agreed to postpone a probable cause hearing, but they vowed to ask the court to reduce the $500,000 cash-only bond for each defendant, and they must pay that before they can actually be released from jail. I don't know about you, but do you have $500,000 laying around if you were having to post that for bail? Most people could not. Well, James Crumley, 45, and Jennifer Crumley, 43, are each charged with 4 counts of involuntary manslaughter. Now, prosecutors allege that the parents acted grossly negligent and caused the death of the 4 teens their son is accused of gunning down on November 30th. The 2 parents were arrested in a building in downtown Detroit after authorities suggested that they were attempting to flee. An attorney for one of the parents said they were scared and were scheduled to turn themselves in. Now, the Crumleys, the parents, on Tuesday again waived any conflict that might manifest by being represented by attorneys within the same law firm. The attorneys representing the duo, Shannon Smith and Mario Lehman, also certified that no conflict exists. I would have to humbly disagree. These parents should have separate independent counsel, not working in the same firm. Although their interests may seem rather focused and on the same page in this moment, that could absolutely change if new evidence were to come about. And if a conflict is to develop, guess what? Both of the attorneys would more than likely have to get off the case. It just makes sense for the court to step in and say, no, we're not doing this. Everyone needs to get their own defense team, and they need to be from separate firms. My humble opinion, I just think it's a conflict. Wouldn't do it, and a lot of judges shouldn't and won't allow it in their courtroom. Now, the defense team has said that they've discussed how to handle this conflict of interest if it should occur down the road, and they're prepared to announce to the court if such conflict arises. Everybody's happy until they lose, and then the first issue they're going to raise on appeal is, I had a ineffective assistance of counsel because there was a conflict. They never should have taken my case. So just be ready for that issue to come about. Now, prosecutors said that the delay of the probable cause hearing contemplated under Michigan law within 21 days of the defendant's arrest is basically a result of the large amount of discovery, and it was described as staggering. In fact, the district attorney rattled off a bunch of reports from her office they were receiving from federal, state, and local agencies, and they said basically the typical protocols for the discovery to be produced would simply not be adequate in this particular situation. The prosecutors noted that the defense joined the request to push the probable cause examination to a future date, and the defense also agreed to a protective order as to the evidence which depicts the shooting and the injuries. A protective order is simply an agreement and an order signed by the court saying you're not going to release this information to any third parties not directly working on this case. So obviously it's attorney, their staff, investigators, or any experts. The material at issue will remain at the prosecutor's office and will be viewable there, but not anywhere else pursuant to the protective order. Now, the prosecutor said the first wave of discovery has been turned over to the defense, but they anticipate a lot more coming that way. Now, Judge Julie Nicholson signed the agreed protective order for the cases against each parent. She also agreed to push the probable cause hearing to February 8th of 2022 at 1:15. Both defendants spoke briefly to the judge by responding in the affirmative that they consented to the delayed probable cause. Now, defense attorney said another motion would be forthcoming regarding the defendant's bond, perhaps as early as this week, depending on the status of the discovery. And as I said earlier, each parent is currently facing a $500,000 cash bail. Judge Nicholson set that motions hearing for January 7th at 1:15 to discuss that motion and any forthcoming upcoming motions. Now, for those of you who are not familiar, Ethan Crumley, who will be tried as an adult, faces 24 charges that include 1 count of terrorism causing death, 4 counts of first-degree murder, 7 counts of assault with intent to murder, and 12 counts of possession of a firearm in the commission of a felony. Now, this is where things get interesting. Now, given the fact that Ethan Crumley will be tried as an adult in the adult system, alleging that he acted under his own autonomy, raises some questions as to whether the decision to bring those charges against his parents could be undermined by the prosecution because of the implied responsibility being placed on the Crumley parents. So the decision to try Ethan Crumley as an adult could have a greater impact on his own parents' case than his. Now, Ethan Crumley, if he's a child who's under the control of his parents, it's less likely that he can independently break that chain from them to these deaths. But by charging him as an adult, the prosecutor is communicating their view that he is an independent actor and that he has the capacity and decision-making capability that an adult will have. So when it comes to making a case for the involuntary manslaughter against the parents, the prosecutor has to prove 2 things. First, gross negligence and causation. Now, in this case, gross negligence would likely require the prosecution to present proof that the parents did not take the proper care to avert the attack that an ordinary person would have, proving the parents culpable by demonstrating potential disregard to a known hazard, so to speak. Now, to prove causation, prosecutors have to establish that the parents caused the deaths in the attack, and the proof must be established in 2 ways. First, the prosecutors must establish that the deaths would not have occurred had the parents not conducted themselves in a certain way. Now, if Crumley used the gun that his parents purchased to carry out the alleged attack, which I think most people believe that is the case, would this be enough? It may not be enough. The second part requires proof that the parents were liable and could be a greater challenge. First, the prosecutors would have to answer whether the attack was something the parents could reasonably foresee actually taking place and given their negligent actions. This is where trying Ethan Crumley as an adult comes into play, because if Ethan Crumley is an adult that acted on his own accord, this breaks the link between the parents and the attack. So it could actually work against him. Now, that's one of the things that we talked about before, and people said, oh my gosh, Scott, you are crazy. You don't know what you're talking about. People said, there's the text message that the mother sent. Now, my understanding is that the parents were called to the school to discuss a situation at school. Apparently, the younger Crumley was seen looking to buy ammunition at school. The parents were called. They also see some drawings that are upsetting to them. I have not seen any information that says the parents knew that the younger Crumley had the firearm at school. There is also no indication, and from what I am aware of, and I'm sure if I'm wrong, somebody will let me know, but the text message that was sent from the mother to the younger Crumley was that was after she heard that there was a report of a shooting at school, where she said, don't do it. Not beforehand. Now, obviously, if it was beforehand, the analysis may change. But if it's after the fact that once the shooting takes place, you can't do it. Now, think about it. I know everybody's upset and everyone's saying, Scott, you're being insensitive. These people knew. Okay, first of all, it's not illegal to give a 14-year-old a firearm. It may not be what you want to do, but it's not illegal. And in this particular situation, the family apparently is involved with firearms. And if not this firearm, there would have been another firearm. So think about this example. If you have children and they go out and you think they're going to be driving to the movies with their friends, but instead they take a frolic and they go out and get booze and they drive across town and somebody dies. Are you responsible for that necessarily? Did you think that was reasonably foreseeable? Maybe you should have gotten the car yourself and driven with them so they could not have had the other kids get in or the booze that were purchased, right? At a certain point, the duty as a parent is cut off under the law. I understand it's an emotional situation. People say, Scott, you're insensitive. No, I'm not. I'm just simply saying what the law is. In fact, let's take a look at what the law says from the Michigan jury instructions. the prosecution has to show, and this is coming straight from the jury instructions, first, that the defendant is charged with the crime of, obviously, involuntary manslaughter, and that you may also consider the lesser charge as involuntary manslaughter. To prove the charge, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of the deceased. That is, that the deceased died as a result of the actions of the parents, right? Third, you have to define gross negligence. We'll do that in a second. And in doing so, the act caused the deceased's death, and the defendant acted in a grossly negligent manner. This act requires the intent to injure. Okay? This act requires the intent to injure. So you basically have to show that the parents wanted this shooting to take place. I'm not sure what evidence you're going to have that's going to prove that particular element. Second, in doing so, the act caused the deceased's death. The defendant intended to injure the deceased, and the act charged in this case is obviously the murder. And it says the prosecution must prove the following beyond a reasonable doubt. First, that the defendant committed the crime, and that the crime used a force of violent touching of the person or someone closely connected with the person, and that the offensive touching must have been intended by the defendant. Okay, ladies and gentlemen, I get it. Everyone thinks, well, you shouldn't have these kids do it, but they have to show that the defendants wanted this to happen. I'm not sure they're going to be able to show that. And then the final element is that the prosecution would have to show that the defendant, remember mom and dad, caused the death without the lawful excuse or justification. Now, let's take a look at the gross negligence instruction. The gross negligence instruction says, gross negligence means more than carelessness. It means a willful disregarding of the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that the defendant knew there was a situation that required the defendant to take the ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another when to a reasonable person it must have been apparent that the result was likely to cause serious injury. Once again, you notice the jury instructions, ladies and gentlemen, it's not meant for a parental responsibility type of claim. Maybe civilly, the parents were going to get sued to the nth degree. Criminally, I think this is somewhat of a novel case, and I'm not sure that the prosecution is going to be able to make this. I'm not even sure, even though a judge has found probable cause, that this is going to hold up. And, like I said, if new facts become available, it may make me change my mind. But as of right now, certainly the son needs to be held accountable. We'll give everybody the presumption of innocence. But this seems a bit of a stretch to try and get a case to stick. Before we go on, let's take a brief recess to hear from our sponsors of today's video, CrimeTalkSearch.com. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Get first, Ghislaine Maxwell. The trial resumes, and the defense is getting ready to call their witnesses in the case. Now, as you may recall, this trial was supposed to last for 6 weeks. The government said thought that their case in chief was going to last most of that time. They ended after the second week. They ended early. First, the judge should be livid that the government said they were going to take that much time, and then they didn't, because all the cases that could have been tried after that and other court matters, not instilling trust and confidence with the United States attorneys for sure. Now, the matter was set over because the government ended their case so quickly that the defense needed time to get their witnesses there because they thought they weren't going to be needed for several more weeks. So they resume today. Now, one of the issues before the court, and the court ruled on it, was the fact that the defense would like some of their witnesses to testify anonymously or under a pseudonym, just like the prosecutor had witnesses do so in their case in chief. And of course, what happened? The defense asked for it. The prosecution objects. Now, why would the prosecution object? Well, they're saying they're not really victims. They're just people that are going to take the stand. Now, first of all, I got a real problem with anybody testifying under a pseudonym in any way. If you're willing to make an allegation, you should be able to come to court and have your name and the allegation that you're making be broadcast to the world. But in this particular case, the prosecution objected because they wanted their cake and eat it too. It's only for our witnesses, not the defense witnesses. Well, the judge says the defense witnesses can, in fact, testify under a pseudonym as well, because frankly, that is just fairness for everybody involved. I just think it's a little ironic, but this is what the government does. Let us do it our way, and you can't do it because you're the defense. And then fortunately, the judge ruled that, hey, if I allowed you to do it, I'm going to allow the defense to do it as well. Now, the first witness that the defense was calling was the secretary to that guy named Jeff, and we'll give you more information as that becomes available. Wouldn't it be nice if that case was in fact televised? Man, I wish it was. All right, let's get to the docket. There's been a lot of talk the last couple of days, and it's frankly, a lot of people are just going crazy over this, but there's this trucker. His name is Rogelio Aguilera Medeiros. Well, he was sentenced on Monday to 110 years in prison for causing a crash on Interstate 70 near Golden, Colorado. And 4 people were killed on April 25th of 2019. Now, since his sentencing, a wave of support for Aguilera Medeiros is gathering online. A petition that has been set up for his name to offer commutation has been set up, and it's going to the governor. And these people want the governor to grant clemency to Rogelio Lazario Aguilera Medeiros. All right, they've collected 2.7 million signatures. Now, Mr. Medeiros is a Cuban immigrant and has contacts with the League of Latin American Citizens, and they are calling on the governor here in Colorado, Jared Polis, to pardon or to commute his sentence. Now, the League also says that it was working on registering a formal complaint of gross misconduct with the Colorado Bar Association against the 1st Judicial District, Alexis King, for abuse of power and official oppression under the color of law, in filing charges against what they believe to be an innocent truck driver who was behind the wheel when his truck's brakes failed. Well, first of all, Alexis King wasn't the DA when the charges were originally filed. King's office has issued a statement, and it said the sentence, which our office requested the minimum sentence, is within the purview of the court and reflects the judgment of the legislature. District Attorney King also wasn't the person, as she stated, who filed the charges against Medeiros. It was the previous district attorney, Peter Ware. Her official response notes that just as the law mandates this outcome, it also provides future opportunity to revisit the sentence. During Mr. Medeiros' trial this past fall, prosecutors portrayed Mr. Medeiros as a reckless individual, while the defense team cast him as a victim of numerous mechanical problems with his truck. Now, Mr. Medeiros testified, and he considered several options when he realized his brakes had failed, including driving onto the grassy median that separates the eastbound and westbound I-70 lanes near what they call the Colorado Mills area or the mall. But he feared that he'd wind up in the path of oncoming traffic on the other side of the highway and that smashing directly into the bridge would cause an explosion, according to his testimony. So he said he attempted to try to slow down by swerving, but unfortunately that didn't prevent the tragedy. Now, in the end, Medeiros was found guilty of 27 of the original 41 charges against him. Included in the guilty verdicts were 4 counts of vehicular homicide, 6 counts of assault in the first degree, extreme indifference, and 10 counts of attempted assault in the first degree, extreme indifference. There were also 2 counts of vehicular assault reckless and 1 count of reckless driving and 4 counts of careless driving causing death. Now, Mr. Medeiros told investigators his brakes failed, yet the district attorney in this case charged him with the first-degree assault and attempted first-degree assault. These are considered crimes of violence under Colorado law, and therefore they have mandatory sentencing convictions, which must run consecutively, which totaled the 110 years. Now, Medeiros was not charged with driving under the influence, but the jury found him guilty of not using a runaway truck ramp when he passed it immediately before the fatal crash. Now, Medeiros had testified that he did not see the runaway truck ramp or the signs. Ultimately, the jury found Mr. Medeiros guilty. So what's the big issue here? Was this more than likely a vehicular homicide case, extreme indifference? What's extreme indifference? Basically, complete disregard for the safety of individuals. When you know your brakes are not working properly or going out, you probably should take reasonable precautions to not drive or stop immediately. And that's would have been the appropriate charge in my humble opinion. And obviously, Mr. Medeiros was found guilty of those charges. But the district attorney, in typical fashion, overcharges the situation. They charged first-degree assault. First-degree assault, extreme indifference, is basically that you intended, by your complete disregard of every situation out there, basically it's equivalent of shooting a firearm into a crowded house. That is extreme indifference, and that's what the jury concluded in this particular case. Now, the jury could have found him not guilty, but they believed that there was sufficient evidence for the charge. All right. He was convicted. My understanding through plea negotiations and a statement by the district attorney was that Mr. Medeiros would only consider taking a guilty plea to a traffic offense. Other than that, he wasn't interested in taking a plea bargain. So he went to trial and rolled the dice. Well, welcome to the judicial system, ladies and gentlemen. Can you blame the prosecutors? Maybe they could have not filed those charges if they thought that it was overkill, but they didn't. They let the jury decide. Can you blame the judge? Well, the judge was brought in as a visiting judge, and he imposed the minimum sentence of 110 years. Now, a motion to reconsider can be filed within 128 days, even on a case where there is a crime of violence. I can tell you, I don't think I've ever had one of those granted, particularly in a crime of violence case. The reality of it is, it's the court saying, hey, you don't like the law? Don't blame me. Go talk to the legislature. I'm just following the law, which is what judges are supposed to do. 110 years, I don't know. For the death of 4 innocent people, some people would say, not enough. Clearly, it's a life sentence. He'll never get out. Even under our sentencing scheme in Colorado, 110 years. Even on a crime of violence where you're supposed to serve 75% with good time, earned time credit, he'll probably get eligible for parole about 50%, which would still make him a very old man if he were to get out. It's good that Mr. Medeiros obviously has people supporting him. That's a very good factor. His first attorney in this particular case, well, he was disbarred. He had some legal issues going on. He has another gentleman that was his attorney throughout the trial, a guy by the name of Jim Colgan. He's a former prosecutor. He bounced around a lot of district attorneys' offices and then ultimately has gone into private practice. It's unclear whether they had the financial resources to properly defend this case, where there were enough experts, so to speak, that could have testified that there's no way that this, in fact, could have been avoided. We will have to wait and see if the governor is going to do something. My guess is he's going to say he's going to leave it to the courts and maybe apply for clemency in the future. Just because somebody who people don't think should go to jail or prison in this particular case for a long time, like I said, talk to your legislator. Everybody likes mandatory minimum sentences until there's that one case where people think, wow, that seems really harsh. Or it's a family member, or it's a defendant who never thought that he'd be in this particular situation. All of a sudden, that seems a little harsh. So we get judges that are appointed here, and they're supposed to be there to make the hard decisions as to what case warrants prison and a lengthy sentence, and those that don't. But when the legislature takes that decision-making out of the judge's hands, this is what you get. Let me know what you think. Too much time? Not enough time? A lot of people have lots of opinions on this. All right, that's all we have for you today. Thanks for watching. Remember, hey, it's almost Christmas. If you want to get that Crime Talk gear, simply hit the link below and get it before Christmas is here. You'll be happy you did. It's good stuff. All right. Thanks for watching. We'll see you next time on Crime Talk.